on Mr. Neville's or Nevitt's own admission, he's not familiar with the individuals that are being referred to within that. So again, I'm parking that there before I move on. I do need to take you through that report, and I hope that the skeleton argument which I've prepared will assist you, because I'm not going to be taking you to every single piece of evidence submitted by the licensees on this occasion. But I will make the following observations in relation to the report in any event. Insofar as the visit on the 23rd of August is concerned, it is right that there was a visit that took place at 10 o'clock at night, 22 hours. Security guards are manning the doors, is what it confirms. They're stationed at the door. They're carrying out admission, security duties. All in all, really, insofar as security is concerned, I cannot, within that first report, identify anything really that is lacking, bar that the SIA badges could not be seen. Now, I'm speculating. It is August, and so I can't say that perhaps they were wearing a coat. I can't put before the committee today information that concerns the weather or even CCTV footage. But in reality, my main submission is that insofar as the SIA agents are concerned, these are not individuals that are employed by Langsbar. They're employed by and through a completely separate contractor. And it is right that they should have their IDs on display. But of course, there's nothing before this committee to show that it wasn't on display and perhaps just obscured by a T-shirt or indeed a high-vis jacket. We don't know that. Those instructing me have provided the committee in any event with a full response in their key issues response that was prepared. And they say that they want to clarify that all security personnel are employed at Langsbar and Cocktail Bar Lounge. They're fully SIA accredited and always wear their identification badges clearly and visibly whilst on duty. This is checked by management at the start of each shift. And so off the back of the East shift that I'm emphasizing, what I will say is that I know that the applicant's position today has been throughout that Langsbar have attempted to put their processes, their protocols, and their policies up to date and have attempted to bring the building up to date. But in reality, the committee should not, off the back of documents having been only received last week, take that as that action have only just been taken. That is not the position. What is before the committee, including in relation to SIA staff and all other policies at the premises, are documents and policies and procedures that have been in place for some time. Whilst I pause there, I'm also going to say, and this is not relevant to the SIA badge policy, but I am going to say that there is also a level of common sense that needs to be applied insofar as observations that are made by someone that is really attending undercover. Because, of course, the individual that's investigating as a consultant has not identified himself as someone that is attending for the purposes of inspection. I think referring to it as undercover is right. It is also relevant that I must say, by way of my opening still, that I know quite a big deal has been made about notices that don't appear to be either compliant or not in the format that the individual observing would prefer it. I reference fire exit notices in that respect, that also refers to keep clear. But insofar as the welfare checks, as well as ask for Angela policies are concerned, it is entirely absurd to expect those policies to be behind the bar. It is something that is created for women that are vulnerable and are more likely to be in the female toilets, and both of the investigators were men. So they weren't going to see it. So what I'm saying is, and I'm saying it because the SIA badges are said to not have been seen as a fallback on that, is that just because it's not seen does not mean that there isn't a policy in place. Those instructing me have made it really clear to me, and I'm confident off the back of the information that they've supplied more recently, that the policies are in place insofar as SIA badges are concerned, including policies that relate to entry of intoxicated persons. The re-entry after 1 o'clock policy, any sort of missing challenge of, checking whether someone is 25 years old, ask Angela, weapon signages, it's all in place. But also policies to deter noise, to investigate noise levels, which I will come to later, and also the dispersal policies. Just because it wasn't available at an investigation does not, as I say, confirm that it is not in existence and it is not in operation. I'm going to pause there for a moment, because what I'd like to do next before I carry on with what's in my skeleton argument is to give Mr. Dawson just an opportunity to address you also, and specifically in relation to the applicant's pack. If you can just introduce yourself, sir.
Hi, I'm Leon. I'm the owner of Langsvar. Where do we start?
If you can start with the footage that was taken of the padlocked gate.
Well, that's all removed. That's all been removed since we had the fire brigade down and they were told to remove that. We've now got push bar there. So the doors are accessible to obviously just push them open for an event of fire. This is all removed. The heaters, they didn't actually even work, to be honest with you. They were left out in the rain and then just put there, try and fix eventually, but no, they've gone.
When he says this, he means the next page, the heaters that were photographed. Can I just also pause you, ask why there was a padlock at the time when the fire brigade attended on the first occasion? What was your common sense reason for having that padlock there?
To stop guests from entering outside, obviously, if it is just a normal bolt, or people leaving the venue who shouldn't, obviously, and people coming in the venue who shouldn't have been in there in the first place. So it's more of a safety thing that the bolt was put on there to kind of protect him with the key just next to it in the event of a fire. But obviously then we were told that wasn't really ideal.
Then several pages over, there were some comments that were made today in relation to a stand or a store that's outside the building. This is on page 11.
Is it the other one?
The other one.
This one
as well.
Yeah, this page was just one.
So this page is a page that was referred to as a food stand that was at the premises, and that the contention was that it was in fact not, it was in the public area, is what was being said. And so firstly, where was that footage taken?
So that's actually off of their TikTok, I believe. That's actually off their TikTok. That's not even in our venue or anywhere near our venue. That's just something they put on their TikTok.
Is
they
that
actually
marketing material for
yeah, it's
them?
marketing material for them. Yes, that's all on their online on their obviously website and TikTok. We didn't actually have any food stalls. We actually just had pizzas ordered to the venue because again they just cancelled on us.
And then if we can just one page back as well, there was a comment that was made in relation to this food stand, or
it's just a stall,
or just this stall, and that this was also not, forgive me, and that this was at the premises also, and that it was on the public highway is the wording that was used. Did you have a license to have this?
Yes.
In what
there was a
form?
temporary one.
It's a temporary events license.
Yes, that's correct.
And then can you just deal with the layout? Is this actually on a public highway at all?
So just next to the driveway of Langs, it's just in between there. There's like a small kind of, how big would you say?
It's a driveway.
Yeah, just a driveway. It was just on the driveway. There was still access to the back building through the side alley and the back alley. So we just kind of had that little bit to ourselves.
Then you wanted to say something about the contention that you didn't have fire inspection at the outset of the building having been purchased by the current landlord.
Yeah, I've never said to Jack that I have not had additional documents that he needed prior. I just said I needed to get them from the previous owner, Ian Whitfield. And that's what I've got to say on that. Do you want to go to brunches? Oh, I mean, you can go on now if you want. The brunches just advertising.
Yeah. And then if you can just deal with the brunches. So the brunches, again, the contention today was that there is an advertisement in the window of Lang's Bar that allows you to order bottomless brunches. What is your position on that?
Yeah, so with the bottomless brunches, obviously, as you can imagine, many bars across the country do them. It is solely just an advertising kind of gimmick to kind of get people to go onto our website and then book. But before booking, they have to read through our terms and conditions and also click to confirm they agree with them, which actually has the details in the restrictions we have on the drinking games aren't allowed, and multiple other rules in place there. And we also place a small leaflet with all them rules and the time frame that their brunch starts on the tables each time they book.
And then finally, in relation to the under 25 age check, do you have anyone at the premises that are under 25 or under 21 that work there?
Yes, I do have people who work there, but we do challenge 25 everybody, even the staff. Even when we have doormen on and the staff still aren't sure themselves, I encourage them to always double check.
I will return to my skeleton argument so we can kind of keep ahead of a structure to my submissions. You will know that I've dealt with the first two bullet points already, and that Mr. Dawson's dealt with that as well by addressing the issue with the fire door. Now, the fire door lock was an external area, and as you've heard, it is now not locked anymore. In fact, there is now a pusher bar that's been installed. I should say that I know that you have, as a committee, already seen an array of documents that's been relied upon by the licensees in relation to fire, including former PAT reports, Lang's Bar fire safety policies, Lang's Bar cocktail lounge fire alarm certifications, fire alarm modification certificates, gas certificates. I don't intend to take you through all of those, but what I will highlight is that it would seem to me that the report that's been prepared, or at least the evidence that's been relied upon by the landlord, the applicant in this matter, relates purely to a fire inspection as stated. And so to that extent, I'll ask you to attach a lot more weight to the communication that we've had from the fire service, and then of course their comments today as well. I would hope that off the back of the evidence that's been placed before you, and also the licensees' most recent comments and evidence that they have produced, that you would be satisfied that there is no concern. Now, I cannot at this stage comment at any length in relation to the difference between the qualification that's highlighted by the fire service and that which is referred to as someone that is suitably qualified. I might say that it is right that very often individuals that undertake reports for the purpose of the county court will be qualified in a very different way as those that are attending on behalf of the fire service. So the question there in my submission for you is, when you make a decision as committee members as to whether in fact the fire regulations had been adhered to, whether the conditions are met, is what standard those conditions should be met at. And that in my submission is not something that is clear from the conditions. I would say that I would invite you, off the evidence that you have from the 23rd of September and the comments and the fact that the fire service are here in attendance today and they are satisfied that there are no issues, that you would find that there isn't a fire risk and that in fact the conditions have not been breached at all. Mr. Dawson has already addressed you on the two people that appeared from the report to have been underage. Now, at no point does the report say whether those individuals are individuals working. It doesn't confirm in the report whether they had a glass of wine in their hands, or when there is a conversation referring to someone saying that they're only 19 years old, that is a conversation that was had with a member of staff. I say that off the basis that I've already made the submission, that this is, of course, a visit that was made to the premises. It is a visit that was made in the absence of those at the premises knowing that anyone is attending, not that they should for the purpose of the investigation, but there is no way of them challenging the recordings within that report, but for the evidence that they're placing before this committee today. And in my submission, there is enough to show that they do have policies to deal with underage, check if 25 individuals, also to ensure that females are safe and that there's smoking policies, no drug policies, and so on and so forth at the premises. I pause on the issue of the evidence that's been produced in relation to drug taking at the premises. Oh, there is not today a Mr. Thomas George Taylor available to give evidence or back up what he said, or apparently has put his signature to. But in reality, this is not something that was brought to the police attention on the evening. And so it's questionable. Really, the evidence in my submission is questionable, because one would think that if there is a drug taking present at the premises in the way that is being described in this evidence, this statement, that if the person putting their signature to that statement is so concerned, that they would contact the police. What I will say to close that submission off is this. There are drug policies in place. You've seen the signage, you've seen the notices, you've seen the procedures. I have been assured that if anyone was to be caught by the owners or their staff at the premises to be engaged in this, the police will be contacted. And in fact, that would be the SIA agents there, the security guards position also. But not only that, they would be banned. You have within the evidence, you've seen at least some correspondence from an SIA agent saying that at least one female has been banned. And so it's not that this is just the licensee saying that that's what would happen. You've seen correspondence confirming that individuals are being banned for being intoxicated. So you can be assured that insofar as drug taking is concerned, that is not a practice, and it is not happening. But in addition to that, what the committee has to recognize is that there are instances, and I'm not conceding that what's being said in the evidence is correct, but there are instances whereby, whether a licensee is Tesco's, Marks and Spencer's, the local yoga club, or indeed Lang's Bar, we're not always in a position to control our customers. And that's got to be taken on board. I'm going to again pause that submission there, and I'm going to tie it into a submission that was made in relation to, well, from the Travelodge really today, which relates to vehicles undertaking donuts in the area. And again, there isn't any CCTV footage that would confirm this. And of course, I will deal with the Travelodge's allegations later on. But what I must say is that whilst Lang's Bar owners are not in a position to control their customers, it is unlikely, when I make that submission, that you should take it as a concession that those leaving Lang's Bar are the ones that are making the donuts in the multi-storey car park. So again, I pause that there until I deal with that evidence. But to clarify, that is not what I'm saying. I'm not conceding that point, and I will move on. With regards to the noise nuisance, this appears to be a sticking point. And of course, we have seen that there's been a proposal for noise management by environmental law, just by way of a proposal also. I have heard and I take on board what the committee says, and of course also what my friend has said in relation to noise level readings. And it is right that the licensees are not qualified noise investigators or noise nuisance investigators, but they have nonetheless demonstrated before you today that they do have a policy in place, that they do monitor noise, and that when they have monitored that noise is shown to be noisier on the end of the Travelodge's side of town due to traffic, is what they will say. There is nothing before this committee to rebut that evidence. So the noise evidence really and noise allegations really have come from the Travel Lodge, and it has been largely documented around information that's obtained via the online, and then also they've confirmed today customers making complaints themselves. There is no way that the licensees can confirm, or in fact, confirm is probably the right word, verify the allegations that have been made when it's made online. It is done in a public forum. But what they've done is they've not ignored it. They've gone one step further, purchased a device, and have put a policy in place to actually monitor what is happening in the area. And I would say that you should be satisfied with the evidence that you have before you. I am going to now pause and just turn my head again so that you can give an explanation as to how that device works. Yeah.
So it's a handheld device that has been calibrated when it's first purchased. And you hold it 1.5 meters up in the air. We do that in the smoking area for 30 seconds. And then we actually go to the boundary of the Travel Lodge and do exactly the same. And the noise readings was lower in the garden, but louder outside the Travel Lodge due to traffic and all the other ambient noise around. And you can see from the reports from this weekend that you can see from the smoking area to the Travel Lodge that it's quieter in the garden, but louder outside the venue.
So there's some readings that appear on a spreadsheet, and it's marked as T and as L.
Yes.
So can you just identify where T is and where L is?
T's the Travel Lodge. And L.
Chair, sorry to interrupt. If I could just object. Obviously, we've been handed figures this morning, but there's none of this subjective commentary on this at all. We've made our positions clear, and now they're elaborating on elements that we can't respond to because we only get to summarise next. And again, we've asked that this be not taken into consideration because no experts ever look at it. These are just figures. And the only point that I would make is obviously this has been ongoing for 4 or 5 weeks to one weekend before. We now have a plan in place that has measurements. Thank you, Chair.
Chair, regarding this evidence, it was introduced before the hearing, although very shortly before the hearing, along with lots of other evidence from all parties. The regulations say it's discretionary, whether you take it into account or not. As Mr. Riske has pointed out, he objects to it being considered. You may wish to consider whether you limit submissions on it, or if you're happy to take submissions and then leave it for you as to how much weight you place on it. Mindful that obviously other parties have not had an opportunity to look into it, and it is quite technical.
Chair, could I also, sorry for not jumping in before Ms. Ward. I would support my friend's submission in relation to this evidence, that it should either be excluded or treated with some very severe caution. It was submitted at a very late stage and has been allowed in. If we're going to go into the level that Mr. Butler is looking to put in front of you, then I say that I need time to put it in front of my experts so I can come back and deal with it. And I'm not in that position today because I wasn't expecting this.
Thank you, Chair. On that basis, I suppose really the subcommittee have two options here. You can either adjourn the rest of the hearing to allow proper submissions to be made on this evidence, or you can take it on the face value that it was provided to you and perhaps limit the submissions on it. Yes.
We will adjourn for a minute to go out and discuss this thing. Thank you very much. We've had a little discussion and Helen will tell you.
Thank you. The licensing subcommittee have decided that they are going to take this evidence as evidence that noise measurements were taken over the weekend, but they're not going to take any submissions on the technical detail within the document.
I am most grateful, and I know that the licensees are very grateful for you at least taking it at face value. As we are on that point, I think it's only right at this stage I clarify that it is, of course, the applicant and then the travel lodge that have made a variety of allegations that concern noise, noise-related, I'd say, breaches of the current licensing. And they've really put the licensees to task, and the licensees have, whilst I accept you would just now look at that at face value, they have gone out of their way to ensure that they comply with the conditions. And this has just been a last attempt to demonstrate to the committee that they are willing to go over and above to ensure that they are in compliance. And so I am grateful to you. But I say this also off the back of identifying that Katie Papworth from Environmental Health has suggested that there has only been one independent complaint really of noise that's been made, and that the proposed noise-related conditions, which appear within the bundle under the heading Langsbar proposed noise-related conditions, are extensive. And so my client's position would be that if these conditions are all put in place, it would have a huge impact on their ability to trade in the way that they are now. It would have a huge impact on their business. And they are already fighting, and I really do emphasize the word fighting, forfeiture proceedings in the county court, which they believe is geared at putting them out of business. And so on that basis, they've done everything they can possibly do to protect their position. They've been put to task. They've done what they've needed to do. But I am grateful for you and to you for your decision. I will move on. I will not elaborate on the proposed noise-related conditions that are contained within the bundle off the back of the submissions that I've made already. If you would like me to address you in relation to each of those, I'm happy to do so. But there is, again, in my submission, a certain level of common sense that can be applied when compared to the current conditions. It's quite clear that those conditions would have a real impact on the business, as I say. I return to the applicant's pack, and in particular, I returned to the investigation and the post-visit report on the 5th of September. Now, I've already highlighted the issues that I have with the additional witness statement that appears within that. Again, my overall observation in relation to that report is that it's actually quite positive. I know that there's still mention of the padlocked gate that only had a key in a breakout box, but that's of course been repaired now. You've seen evidence to that extent. You've also heard it. You have some note within the report that relates to an incident that has not been really, I'd say, reported to the management on the evening. And with that, I mean the reference to the scuffle between gentlemen. Nobody really knows what's happened there. It is a report that may well have been misunderstood, but either way, the licensees have assured me that their staff members do not accept cash from customers. And if they were to accept cash from customers for any sort of favors, that would be an instance whereby they would almost certainly immediately dismissed. There is a policy that applies to their staff. There's training that applies to their staff. And if there is ever an incident where a group of men appear to be in a scenario where they're escalating their argument, certainly management would be notified immediately. So this is an allegation that cannot be met in the absence of actually knowing who it was that the allegation is made of. But I say this because I am aware, and those instructing me are aware, that an allegation of that nature may paint the way that they run their pub or their bar in a very, very bad light. And they want to assure you that that is not something that happens at the premises. Again, insofar as policies are concerned, there's quite a bit that's been said about dispersal of individuals. If anything, the report actually paints Langsbar in quite a good light, in that it doesn't seem to say that there are issues with emergency services needing to be called out, unlike my clients would say to the committee is a case at the Travelodge, where emergency services are very often called out and quite a lot of noise do occur, and that is their observation. But I would say that there's the attention that really should be paid should be to the content of the report and recommendations that are made. The premises as such is not found in this report, which is supposedly an independent report, to fail a risk assessment as a whole. There are comments that are made as to how it may be improved, but it certainly does not meet, I'd say, the standard of what one would say needs to be met in order to substantiate that there's been no compliance with the conditions. And so it doesn't really, in my submission, take the committee any further, but for that the committee can, off the back of that, say, these are the investigations that are taking place, these are the observations that have been made, and this is how the licensees have actually taken steps to actually address that. Then, in the section that is headed licensees evidence, you'll note that I have divided reference to evidence under different headings. I have in part already dealt with the environmental health complaint. I've confirmed that there is a confirmation from Katie Pathworth in an email that's dated the 14th of October 2025, I think, that says that she would propose that there's some noise management plan that can be put in place. I am very hesitant to invite you to look even at that noise management plan for the reasons that I've stated already above. It is also right that a noise management plan doesn't necessarily need to be incorporated in conditions. That's a matter for you. But that is what I would say as a closing submission on that. The noise complaint, in any event, as I read it, was from a member of public at a bus stop. So not outside of Langsbar, but at a bus stop at a completely different place. There is also an email from PC Andrew Smuts, and he confirms that there are no significant incidents reported. And that email is, of course, dated the 4th of November 2025. If anything, he confirms within his email that he has absolutely no concern about this venue. Then, insofar as antisocial behaviour is concerned, the licensees have provided you with rebutting evidence. What we will say is antisocial behaviour is referred to loosely within allegations made by the applicants, and of course also referred to, I'd say, in the context of what the Travelodge is saying. And I know that there's at least some reference to damage to furniture, street furniture, but there is no evidence before this committee that would confirm that the individuals that have caused that damage did in fact come from Langsbar. It's right that the individuals that walk along the pavement and the streets in this town are not all visitors to Langsbar. And so there is a presumption, almost by association, that anyone that's causing trouble for some reason comes from Langsbar, when more official individuals, such as the police and, in fact, environmental health, and from my understanding, and I know they will correct me if I'm wrong, the fire service would say they do not have, that is not their experience of the visitors to Langsbar. And so I would say any sort of allegation of ASB or vandalism, which relates to 10th of October 2025, that's something that you can ignore. In any event, furniture further away from Langsbar is being affected by vandalism or any sort of bad behaviour. As I say, it's not necessarily the patrons of Langsbar, but it's also questionable as to how Langsbar should control the way that individuals behave all over town. That is a very, very large onus that is placed on them, which is quite frankly unfair, and it's just not substantiated. Again, I return to the public nuisance allegation that's made. This is the Forum of Preventing Public Nuisance that's referred to the 10th of October. Again, I will just highlight that, again, PC Smuts also dealt with that allegation. And then there was further reference to the Forum for Supervision and Control on the 10th of October as well. Again, PC Smuts evidence itself rebuts that. Then there was an allegation that related to Citando ASB. Also, same thing. There isn't any evidence really before the committee today to deal with that. If anything, there's reference to that individuals are spilling over into Citando when the police has rebutted that also. And the same can be said in relation to the vandalism that they are alleged to have been a subject of or entertaining on the 13th of October. I focus now on the Travel Lodge. So there is this more recent complaint that relates to room 102, which I've dealt with further down in my skeleton argument. And you will note, as I've said previously, a lot of what's added in the additional document licensee see photographic evidence heading within the skeleton argument is evidence that have been obtained with the aim of assisting the committee, but does not by any means mean that the committee has got to take this as action that's only recently been taken. Of course, we were all here 2 weeks ago, ready to go, no criticism intended. But in the same way as the Travel Lodge's allegations may have evolved, if I may call it that, the evidence that's been placed before the committee has also evolved. And so in response to the Travel Lodge's most recent complaints, again, what has been provided by the licensees more recently, and this is now the 7-page document that you've had recently, or the 7 attachment documents you've had recently, within that you will see that there are several spaces within it that refers to the objectives, the policies, the noise monitoring equipment that's now been referred to today as well, location management, including smoking areas, that's always been in place, staff training, customer noise control, measurements that have now been taken over the weekend, music and entertainment, and then page 4, complaints procedures, which are in place in any event and always have been. Focusing on the complaint in relation to room 102, I'm not going to go into the readings, but I am going to say that the policy now is that readings have, since the purchase of the equipment, been taken quite frequently. And over the weekend, certainly with the aim of rebutting what's been placed before the committee today by way of a complaint, it was done for 2 days consistently. I'm aware that we cannot go into the technicalities of how the equipment works, but I'm sure that you will allow me on face value to refer to the hourly garden noise check procedure that's been put in place and the evidence that...
Sure, sorry to be a pain. Can I object again?
So there's no need, thank you. The subcommittee aren't taking any submissions on the content of the recordings themselves, purely the fact that the noise recordings were taken. Okay.
By way of face value, be assured that that is not an exercise that was just undertaken over the weekend, but it is one that will continue to be undertaken, particularly in light of the complaints that are also before the county court. Now, whilst those complaints are concerned, and I know we're not going to go into it much, with the aim of achieving forfeiture, it does relate to breaches by the licensees and the county court. And so you have some assurances that they will continue to comply and adopt the procedures that they've put in place, and also continue to carry out and fulfill the procedures that they have in place, so as to also not find themselves to be criticised in the county court. There was today much emphasis on the bottomless brunch, in particular in relation to the sparkler risk. Now, there is a sparkler risk assessment and disposal, terms and conditions of the bottomless brunch that was also placed before you 2 weeks ago, as well as additional risk of use an ice fountain during bottomless brunch assessment. So again, what the licensees will say is that the evidence you have before you has really plugged every single hole, not just as a sort of retrospective, reactive way of dealing with the allegations, but because they do have procedures in place. They are familiar with the risk assessments that they have to undertake. And I can say comfortably that that's been the case for some time, because what's been placed before you in any event by the applicant certainly relates to bottomless brunches, as well as the Langsfest that they've complained of, that dates some time ago. On face value, the photographs date back to May the 2nd, 2023. Now, the committee will know that when a temporary events license is granted, it comes with conditions. And so those conditions would have had to be met in 2023 already.
I just clarified, temporary event notices aren't necessarily subject to conditions. Do you mean?
Conditions in the sense of there would have to be risk assessments that's adhered to, and there would be a plan of what area they can occupy, and that there should be basic conditions that apply to the actual license for that event.
A temporary events notice will identify the area to which it applies. It doesn't have conditions about risk assessments as such applied to it. That would be a subject for other legislation. But
yeah. But either way, it is right, and I think the legal advisor will confirm that the temporary events license has to be applied for. And if there's ongoing issues at the venue, it's unlikely that it would be granted. I say that just by way of note, in that if a venue that has ongoing issues will not have it granted. So, in relation to the Langsfest complaint, as we're on it, I have already highlighted that there was actually no food truck. So the allegation that there was a food truck in a public area and that it's in some way breached the conditions of the premises is something that's entirely inaccurate. Granted, it is right that it was advertised that there would be a food truck, and it is also right that the photograph that you were taken of as a still of a video, which was really just a marketing tool, does seem to relate to a food truck, but it has been confirmed to you today that they didn't even show up. And so that video is not by any means anything that you can attach any weight to, because it doesn't even relate to the premises. Again, just by way of complete clarification, where there are allegations as to the Langsfest complaint, there certainly would be SIA that would be present on the day. Again, fire safety regulations have to be adhered to, including all the risk assessments. Attendees would be supervised. Again, individuals have to book online in the same way as they do when they book for the bottomless lunches. And they would be supervised by way of the purchase of their tickets, and certainly ejected and asked to leave if they do not behave. And of course, the word behave you can interpret in any way, shape or form you like, but there are policies in place, including policies that relate to the gardens, equipment in the gardens, lighting, gas heaters, electric heaters. All of that have been provided to you again today, with the aim of substantiating, or I should say Friday when it was emailed through, substantiating that we are really sticking to the rules here and trying to adhere, or at least we say we are adhering to the conditions attached to this license. Finally, there was a comment. I know my friend hasn't made a very big deal of this today, but there was certainly a comment in relation to a flower wall and LED again, you've been provided with the warranty and distribution and manufacturer's note in relation to that also. And so you have a fair amount of evidence that you can go through when you do consider whether you can be satisfied that the conditions have been breached. My closing submissions then will be the following. I have already identified that there is an acrimonious relationship between the parties. What I will say as my very, very last submission on that is this. It is not right to say that the DPS is not cooperated with his landlord. In reality, perhaps not as unusual, but it is certainly a little bit unusual to be faced as a committee with a scenario such as this, because there are forfeiture proceedings in the county court and the licensees have to protect their tenancy. They have had to instruct the solicitor to act on their behalf. And so when there is any sort of allegation of them not cooperating, that cannot be taken at face value, because there is now this individual that is between them and the landlord solicitors. So I am not satisfied on face value, and I say that you shouldn't be either, that there hasn't been a cooperation. The reality is what we have in the applicant's pack, to the back of it, certainly a reference to several emails with Emma is a first name. In some places, Leon Dawson has been copied in also, but mainly with her. And that is all in relation to compliance with the license, but also other issues that relate to the forfeiture proceedings. And so to say that there hasn't been cooperation, it's only really that there's this filter of an individual solicitor in between, and you can take that as face value. And so I firmly, and certainly both the licensees firmly reject that they haven't been cooperating. They have, and I hope that you can see from the level of evidence that they supplied you with, they have certainly cooperated with this forum before this subcommittee in the same way as they have done with the county court. I am not going to say anything else about the county court proceedings because I don't think that it's helpful. My primary submission has got to be that it does, from their perspective, feel like what is before the licensing committee is quite retaliatory, and that it is just another way to try and get them to have, well, try and achieve a forfeiture finding, almost by way of I'd say, facilitating the committee to make a finding that can be relied upon in the county court. And again, I leave that there, but that certainly is their feeling, and I wouldn't be doing them justice if I don't say that. And then finally, the licensing committee does have before it today correspondence from the employers of the SIA security agents also. That is independent, but also further correspondence that specifically relate to the Security Industry Agency, and that is a prosecutory authority that can, when they are not happy with the way that that security guards are behaving, or if they're not compliant, undertake an investigation. Now, I say a lot of weight has got to be attached to that, because a lot have been said today about SIA agents and the way that the premises are being managed. But the fact that they're not being prosecuted or investigated in my submission, when there is an entirely different regulatory authority that can investigate them, a lot of weight should be attached to that, because that in my submission would prove, and really is substantial evidence, that there is no issue with the SIA staff that are attending and employed at the premises at all. I have already made the submission that certainly the licensees do not feel that the consultant's report is unbiased, and I've raised the issues that I have with the documents that are contained within that, particularly the email that we had understood from the way that it had been presented this morning that it's in fact a report when it is not. And I have already emphasised that insofar as Kent Fire and Rescue own concerns goes, their investigation was quite recent in September, and they satisfied with the standard. You're already aware of the Licensing Act 2003. You're aware that what the statutory licensing objectives are. I don't think I have to remind you of that, but ultimately it is prevention of crime and disorder, public safety, prevention of public nuisance, protection of children from harm. And you know how to apply your policy. Do you have any questions for me at this stage that I can assist with, or from either of the licensees in relation to specific matters?
Have you got any questions? You'll make comments now. Wait till we talk. Yeah, wait till we talk. Yeah. Not at this stage.
Is there anything else?
The only comment I've got is taxi drivers, the ranks across the road, because I know the area quite well. Do you have a direct line to phone for them for a taxi, or are you likely to?
The bar as well.
You do?
Yeah.
Thank you.
That is actually included in the information was provided previously as well. And there are some statements amongst the documents that come from taxi drivers directly as well. If that assists, I can find it for you if it's going to assist you, but that is available.
Did see the taxi driver said that there was no problems, and they do like picking up from
Yeah.
the venue in the evening, but I wondered how the client contacted them.
In fact, I have just been reminded as well to assist the committee that there is actually a discount that's available to customers if they book through the venue. So not only will you find an array of information that's available to call, but if they call from the venue, they will have a discount. So there's a real reason to book and not be walking away.
Helen? Yes.
Thank you very much. I've got a few questions on some of the specific concerns that have been raised. One of which was younger people in the venue. Now, you've got a condition on your license that customers have to be 21 or over. But there is evidence that the bottomless branches, your terms and conditions relate to over 18s. So can you explain why your terms and conditions say over 18s when you do have that condition about over 21s? If it helps, I'm looking at the first agenda that was published, page 56, terms of service.
But then
The license condition specifically says, and we're on page 15 of the agenda. Is it page 15 or is it page 60? Condition 4, entry to the premises is restricted to persons 21 years of age and over, albeit slightly conflicting with condition 3, which says that children must be accompanied by an adult and off the premises by 7 p.m. Now, regardless of the presence of slightly conflicting conditions, perhaps it might help if you can clarify your position regarding people under the age of 21 for the committee. Thank you.
Yeah, well, we usually stick to that.
the evenings is definitely over
Very
21.
strictly over 21s in the evenings. That's why the doorman obviously ID them. We do sometimes get asked from customers via email. They have an 18-year-old coming with them. Obviously, they won't be drinking. They might have a glass prosecco or something. So we do sometimes allow that.
Thank you very much for clarifying
The
that.
brunches do finish at 5 as well. So usually the venue, everyone's out the venue by 6. We close for an hour, and then obviously we open back up for the evening.
Thank you. Just with regards to that particular point on the brunches, bear with me one moment. It says on your website that there is an after party from 8 p.m. to 2 a.m.
So yeah, the bar closes
Yep.
at 6 till 7, so the girls can do a clean up, and then obviously get the tables away and everything, and then we open up as the evening, in a sense.
Does the premises completely close?
We close, yeah, for an hour.
So people would go away and
Everyone goes out.
come back? So on to the bottomless brunches then, if I can ask just a couple of questions on that to help the committee. There has been submissions made that these are irresponsible
promotions. Now, what that means is it would carry a significant risk of undermining the licensing objectives. I think it will help the committee to understand this a bit more if you could explain exactly what happens. So I know you've put pictures in of trees. If someone were to, or a group were to have a tree put on their table at the beginning and they drink all of that quite quickly, what happens
We
next?
do have a pause time. So usually peers will come and check with, well, we talk between each other, and if they're drinking too fast, then there's a cut-off point for them.
Cooling off period.
Yeah, cooling off period, basically.
I can just highlight as well that the bottomless brunch terms and conditions, which appear on the website, that does also appear within our evidence. It's a page that is headed bottomless brunch T&C, and it refers to, it's got some yellow bits over it that specifically highlights bottomless can be stopped at any time if found breaking the rules. For example, downing of drinks, playing drinks games, found bringing their own alcohol brought into the venue, bottomless will be stopped immediately. It deals even with the policy in relation to VIP event table bookings, that is not refundable. And also specifically at the bottom clarifies groups of a maximum of 5 and 3 trees. So there is, even in the terms and conditions, there's a limit of how much can be purchased. I know that my clients were hesitant to say this, but of course the cocktails itself, there's actually a very small amount of alcohol due to the way that it's mixed. It is a tree for a reason, and they're certainly adhering to the alcohol laws, and in fact not serving over what should be served by law.
Thank you. Just one more for me, please, Chair. Could you explain, Mr. Dawson, you introduced yourself as the owner, but I know Mr. Butler is the license holder and the DPS. Perhaps if you could just explain about how you run the premises and your staff and how your staff are trained, and some information about that would be helpful.
Yeah, so I deal with the business side of it mainly, so like the finances, etc. We work together on the policies that are in place and obviously training. We do a lot of research in other venues to kind of get a pinpoint of where we should be. We work with, well, I don't say we work with Wetherspoons, but we're very close with the Wetherspoons management. So we tend to try and copy a lot of their policies and implement them. There we go. At Langs. So yeah, we've been there for a while now, and we've always tried to strive to have, if not the best bar in town, and try and kind of, we've been there longer than a lot of bars have been there in the sense of new ownerships and stuff. So we think we're doing something right in that sense. So we definitely try and stick above water.
Thank you. How many people do you employ on an average Friday, Saturday?
So there will be peers, 2. So Friday night there'll be 2 doormen. Saturday night there'll be 3 doormen. We just find it's safe to have extra people there just for the garden. Then there's peers, myself, and 2 other members of staff. But that's on the Friday. There's 1 less.
Thank you. And have you ever run other licensed premises, or is this your first? I know you've been there for some time.
Yeah, I've been a manager of a licensed premises in Upchurch before, since I was 18.
Thank you. I've only got one question. Do you sell non-alcoholic drinks?
Yeah, we do. We do have gin.
Thank you.
And often beers as well.
Thank you very much. Thanks. Perhaps you can clarify for me, because I was a little confused when we were talking about the license. The condition about entry to persons who are 21 years of age and over, how does that apply?
Challenge 25. All the doormen check IDs, and if the staff still aren't comfortable with it, they check as well.
and people who come to your premises know that it's only 21.
Yes, yeah,
Very well known in
How do they
Sittingbourne.
know?
because we're well known in Sittingbourne. We're very well
I
known.
don't know that. So how does everybody know that it's only 21 years of age? You know, there's no signage up there. That's what I'm coming to.
I mean, usually they learn through trying to get in, and I mean, it's stuff we've had this in place for a long time, so it's just something that town's known for. Well, for us, really, we just kind of second nature to us.
I'm going to be quite straight with you, but I think it's otherwise we're going to take a long time over this. I'm going to suggest to you that in fact you don't operate a 21 years and over age policy. Your doorman may well take ID, may well check ages, but they're looking for people to operate a system where you ignore that condition.
We wouldn't ignore that condition because over 21 is in place for a reason. Because the actual high street is known for trouble, hence why we put that condition in there. So we don't have the 18-year-olds coming over and causing fights, hence why we've had no problems.
And in relation to admission fee after midnight, there's no admission fee charged.
So we include that in the prices. Potentially, we could change that and charge on the door, but then we'd be the only venue in town charging on the door. So we just include that into the price of the first round. Generally, well, the girls will do it as they go along.
So drinks are more expensive when I first go into your place than if I've been there for some time.
No, we include it over an average of all the drinks.
Sorry, so how does that?
We just add 10% on.
So is that on your drinks price list that it will tell me that it's that's the price of drink and there's a 10%
No,
charge for admission?
we include that in the drinks ourselves, so we don't tell them that. So the prices are a set price with that in place. So rather than picking at every individual who comes in, we just have that as a broad, this is what we kind of do.
So the prices after midnight more expensive than before?
Yes.
Okay, so, and is that clear from your bar?
But staff are aware of it, yeah. Staff are aware of it.
Are customers aware of it? That's what I'm asking. Are customers aware? They're coming in, they're purchasing drinks. It's only fair, isn't it? What you would expect. If you go in there, you purchase a drink, you want to know the price of it.
Potentially, but it is off-putting as well to customers if we're charging them at the door, which we've obviously told this for a long time, and we'd be the only venue in town charging on the door.
Now, you've had the application. The application was served, as I understand it, it's in September, 16th September.
Yeah.
And you would have got a copy of this on the 16th of September.
I believe if you would have emailed it, and I think I put one copy of this come in the post as well. Yeah.
So 16th.
I don't remember the exact date.
Around that date. Okay. And with the application, there comes documents, basically in Appendix 3 of the committee bundle, which is the reports from the consultants, Mr. Bailey and Mr. Nevitt. And Mr. Bailey sets out a whole load of things that he says are not happening. SIA badges not being displayed. Entry of intoxicated patrons. Challenge 25, weapons awareness. Fire exit blocked. Noise after 1:30. Re-entry after 1 o'clock. SAA badges not visible. Best way of dealing with that, if you disagree with it, isn't it, is to bring the CCTV.
We have CCTV. We took CCTV.
And so
We have it
you've
up to
got
a month.
CCTV, of this particular date in September?
No, I don't know if it's that particular date because that was.
Sorry, he's in August. So
He's
he's in August.
you might have it.
He goes in on the 23rd of August. And the way of tackling this is that you've got
Find it.
CCTV,
Yeah,
but you
find
don't tell anyone about it. And indeed, we could have gone through the whole hearing today without anyone mentioning CCTV at all.
Well,
It's only when I raise it, yes, we've got it.
Well, actually, I did respond to the email while I was also communicating with Emma, asking if she was going to deal with complete licensing. And I did say to the gentleman in my email that obviously I strongly disagree and I would like evidence to this. So it's his word really against ours, because Outdoorman, I mean, we've had licensing checks yearly. I mean, they come down multiple times a year. They've always got their badges on them.
So we've got the two reports on the 5th of September. I've gone through Mr. Bailey's. Mr. Nabbit gave his evidence to the committee this morning. And he refers to young people in the premises. His estimate was that the customers were late teens into their early 20s. Again, surely the CCTV evidence would be really important.
I mean, again, not to sound modest, but I look younger for my age than I am. So to just gauge their age on just physical appearance is not really fair.
It'll be the 24th because it'll be the following, because it'll be past midnight.
So Mr. Nevitt is there to help you. So he's there on the 5th of September, and the other person is on the
23rd of August, yeah.
Thank you, 23rd of August.
So it will be CCTV from the 23rd until the 24th of August because it's after 12, isn't it?
Cool.
Yeah.
So, okay, so we're saying we do have CCTV. Those particular
saying we
dates,
do
but
have it.
we
We're going to try and get it now.
release anything, Paul, in relation to that. So you also say, don't you, that the bit about the padlock on the fire escape was wrong, isn't it? You say we don't accept that at all.
What do you mean we don't accept that at all?
Well, in your evidence, you say that we're mistaken. The evidence is not correct, that there is no padlock on any of
There's
the-
two fire exits. He was just referring to the one at the bottom. The one at the top didn't have the padlock on it.
Okay, so you say there's no on the door.
No, on the bottom one there was, but that's been removed since. We had a smashed glass kind of key holder in it. We thought that would be sufficient. Obviously, we've been told otherwise since, and that has been removed.
So, so I think this is page 59 of your bundle. I think this is the bundle that was produced at the last hearing. And in that, where it says padlock fire exit, bracket, incorrect observation, we respectfully confirm that there are no padlocked or obstructed fire exits on site. So you're saying that's wrong?
So since the fire brigade come down the second time, we were advised that that should be removed, and it has since been removed.
And they attend in September. But what you're saying at page 59 is not that, is it? What you're saying is, irrespective of what the fire officer says, you're saying there are no padlocked or obstructed fire exits on site.
I just said there's two. There's two fire exits. One at the top doesn't have a padlock. The one at the bottom does, and it did. And then
Now removed it.
that's removed, yes.
So we then go to into your documentation. Now I have this, my identification purposes as PLH1, because that's how it was sent to me. But I appreciate that I may be the only person working in that with that description, because as I say, that's how it was sent to me. think about the local authority.
Just by way of clarification, PLH1 is the way the local authority has sent it, but it was sent previously as one.
I appreciate that it may well
Yeah.
go break up, but I'm just
Yeah.
trying to help people as to where I am. So that talked about Langsbest. Now, in relation to Langsbest, you're saying, as I understood it earlier, and I may have misunderstood you, that there's a picture of a unit,
The video.
and you're saying that wasn't there.
That
Correct.
wasn't there.
That's your, isn't that your social media account? Is that your Facebook?
It is, yeah. So they sent that as marketing material to advertise that they were going to be at the event on that day. And then you'll see the text messages that they actually said that they couldn't attend the venue.
Okay, so for the purpose of that, you're saying is, well, yes, it is on your Facebook account, but basically they don't turn up and this confirms that.
Correct.
And just to clarify, that's their marketing. So the photograph is actually taken, the video is taken elsewhere. It's offsite. It's not, it doesn't actually relate to Langsbar at all.
It's the case that it's my error. So I thought that it looked like the car park. of St.
Yeah, no,
Michael's Town.
that's why we're here.
And
So
the tree in the background that was there before. So it looked like that. So if that's wrong, then it's my mistake.
it's good.
There would be a wall there in that case.
Yeah.
So then we go to PLH2, which is photographs of signage. Now that signage, the Asperangela, and I think it's two different signs there. That signage that you've put up since these proceedings started.
No, they've always been in place.
So you're
And
saying
Leon's
that
got,
these have always been there?
So I have, did you submit the,
I hadn't got those.
well, I've got emails from the local police side. Wait, I can get her name for you if you want. I email her every 6 months or so and say, can I just have another load of posters, please? And then she prints them off and says, come collect them.
So you're saying to me and to the committee that the evidence again from Mr. Bailey and Mr. Evatt talk about not being able to see any of these signs. They don't see the signs, but they're there.
So if you just went into the men's toilet, I will be completely honest, men do rip the signs down in the toilet occasionally. We have to go through a lot of signs. But if on that occasion there wasn't any, I mean, we have signs generally all over the place. We have the taxi signs where they get 15% off. We have Ask Angela. We also now have that in the men's as well.
Spiking and drink driving is also
Yeah.
in there that we got delivered by Kent Police.
Yeah.
So these signs that you're putting to the committee today, where are those signs located?
So we have, so there's one in each cubicle of the females' toilets on the back of the door. And then there's one above the hand dryer. Where's the other one?
One next to the mirrors.
One next to the mirror. So about four in the females, and there's 4 in the men's. Yeah, 4 in the men's as well.
And any in the bar?
Not for Ask Angela. But we do have Challenge 25, the generic.
25 supposed to touch.
Where's Ask Angela, isn't it?
No signs saying that that the minimum age is 21 for coming in here.
On the front door there is, yes.
So on the front door.
Where
there's
there's a
sign
black
that
poster.
Over 21 zone.
It will say the opening hours, and then there's a little bit of writing underneath also to say security and management refuse the right to not allow people in over 21s.
That's not the same as what I've just said. I've just said that there's a sign which says that no persons under 21 can be admitted into the premises.
You mean a sign by itself, but there wouldn't be one by itself, but there's one integrated with all the times
What
and the
you're saying
rules.
is that you've got the right to refuse admission.
No, it says they can refuse
The right
anybody they
entry.
feel is not fit for entry, and then on a separate line it says over 21s only.
Okay. And you're saying you complied with that condition on your licence, even though I think you.
But the doorman are meant to do that. And the staff also checked that. So
Now, I think I'm still on PLH two, licensing signage.
Sorry, I had supplementary question. I thought it was going to be an appropriate time to ask, seeing as we're talking about this, because regarding the under 21s, you have explained to the committee that there are times when you do allow people in who are under the age of 21, contrary to the condition on your licence.
for the brunch,
For
the brunch,
the brunch.
brunch,
But are you saying that in the evenings it's,
Correct.
strictly, but
during the day,
during the day.
under 21s
Yeah.
are allowed access?
Over 18. then.
Not regularly. It's generally, like I mentioned earlier, if they email, say, like a parent would say, their daughter's 18, can she come down? Then there's obviously a different kind of package. We kind of put them in a different category altogether.
Thank you. I wanted to clarify that, Chair, because the position isn't quite
Yeah.
clear what's being said.
Thank you. And thank you, Jill. Okay, so then we go to we've got licensing signage, and then there's some photographs, I think, of the rear area pergola. And it's those photographs are in black and white.
Correct, yes.
Okay, and I think if you look to the back of the room on that, that's a fire escape, as I understand it. And then there's a close-up of that same fire escape, which is the next photograph.
Correct. That's to show that the emergency light is installed in the garden, because the fire safety report that you guys submitted said that that wasn't there.
And also you can see there's no padlock on that.
Yeah. I have colour photographs if the committee do not have that, because I have the electronic ones. I'm happy to place that before the committee as well.
I think it's got colour. I'm working on black and white, but I can see the images. Now the next photograph is of a door with a step. Now, as I understand it, that's the step that the fire expert is recommending be removed. Is that right?
Well, that was originally used as a stage.
Can we just, forgive me, may I check just which one it is you're referring to? Because
This one I think would benefit for the version, it's the black and white version.
is it this one?
I believe it is, yes.
Yes, that used to be a stage.
Right.
And that's just a step that will be removed. I don't know if that.
Does that lead to an exit or is that?
No, that's a stage for when we have a singer in the garden.
Okay. You have live music in the garden from time to time.
Only in the summer when it's too hot for individuals to have the brunch indoors.
So that's a stage.
Well, it's actually used as nothing at the moment. It was a stage as such, but
I'm only trying to work my way through these photographs because none of them are labelled. Not clear what they relate to. So we then have a photograph which I'm not sure what.
they're electric heaters.
They're electric heaters. So that's the removal of the heaters that you say you've taken down because they didn't work.
But they didn't work, and I'm sure some kind of fire assessment would have come up against them.
So they've been removed. And then there's a photograph of a door, gate,
Yep.
door.
Thanks, Dan.
That's
And that's labelled as fire escape.
Yep.
Correct.
But it's not, is it?
It is. They've listed it as a fire escape. Oh,
It's not a fire escape, 'cause you don't have any right of access to it.
To what's behind it's a car park, but if we've been advised, if the landlord chooses to restrict customers going out there in the instant of a fire, then that obviously wouldn't be our responsibility. We can use that because it accesses straight to a car park. So
So even though you don't have any right of way, somebody
It's also
replies
leads
to
into
you
public
that that's
parkway, doesn't it?
okay, you can use that for your own.
Fire assessor that just come down 3 days ago agreed that there could be a fire exit.
Just to clarify, under Article 22 of the Fire Safety Order, you have a legal responsibility for cooperation and coordination. You can't block that fire exit. You do not have to have permission to go across it. In the event of an emergency, you can use it.
Shows a fire escape to the side of the property that leads out to where the gentlemen park their vehicles. That is the fire escape as far as I'm aware. The gate at the back, the lease clearly states that is only to be used for access to carry out maintenance with prior notice. I know that's not your area, but I'm just explaining to you that we're not blocking a fire escape. It never has been a fire escape. When the one that is there is the one to the side, not the one at the back that leads out onto land that is nothing to do with Langsbar. So from
But even if the land, they would still have to have access to carry out maintenance.
the other side of that gate is car parking spaces. There might be a car parked right up against that gate.
Not for you to say, is it? It's someone else's land.
There's 2 cars parked to get out. So it's best not to say that, because if we do say that and someone tries to open that to try and get out and there's a car behind it or a bike behind it or something, it's not, it's the one to the side. They've got one.
So can I,
Yeah. I'm not-
Building, to a relative place of safety.
Yeah.
Well, you then have to look at going to an ultimate place of safety, which if, they should be made available at all material times.
But I think what we're saying is it's labelled as a fire escape, but it shouldn't be because it isn't. I think that's the point. And I think I understand what you're saying. If it's a fire escape, then we have to facilitate access to it and through it. And I think what we're saying is it isn't a fire escape.
can I clarify a point? Which one was padlocked? So the other one. But would the consultants have been aware of the difference when they carried out their visit? How? So you advised the consultants.
Just to point, that gate opens inwards. So unless a car had actually parked so it was touching that fence, you could get around it. The gate opens inwards.
If it shouldn't be used as a fire escape, it shouldn't be used as a fire escape. Nothing is going to make it a fire escape if it shouldn't be a fire escape.
Well, they're called final escapes, not fire escapes. So therefore, that is a final escape from that garden.
That's fine, but when you open that door and get through to the other side, if there's 2 cars parked like that, you won't be able to get past them. It's and also we're talking about people leaving Langsbar, going out onto the car park of a building next door, where there's cars on the other side of it. I don't agree. I think, the fire escape is the fire escape, which is the one on the left-hand side that leads out onto their own land that is fully within their control.
Final escapes just mean you can get to ultimate safety, and that gate does.
Could we move on from this? We know we're getting bogged down a bit. Thank you.
Yep, no, understood. So there's a disagreement between us whether it should be labelled as a fire escape, but moving on from that particular issue, we then go into Langsfest, and the suggestion appears to be that you get a temporary event notice and you can do anything within the temporary event notice wherever you want, as long as the temporary event notice covers it. That seems to be the suggestion that's being put forward on your behalf.
Just to be clear, that was only once that it's been granted. It doesn't happen every year.
And the temporary event notice, Paul, was for a location either on the public highway or it was on the service road, as I understand it.
I can't understand how they have an license to do that, because it is the only road that leads into the car park of St Michael's House. So if they really do have this permission to do it, then the council would have given them permission to block the single access road leading to another building.
I think what we're suggesting is that in the temporary event notice, it's for a particular location, but you had no permission to actually hold that event at that location.
Well, the temporary event notice, well, the license was granted, and at the time, St Michael's House wasn't occupied, as I understand it. So there was no breach of that notice or that license at all. And there isn't anything I should just say to the committee before the committee to suggest otherwise. There's a couple of pictures.
Well, you're accepting it's not your land. And you're also accepting that you don't have permission to take control of that land.
The NHS was based there at the time, and they did, well, not
Sorry,
by
sorry to
yourselves.
intervene. The licensing subcommittee are only going to be considering matters relating to the licensing objectives, not proprietorial interest in the land, I think.
It's to do more with the attitude in relation to these things. Moving on, I think this is PLH 3. And again, this is clarification as to what these are. So then I've got a photograph of drink driving, spiking. Are they signs that have always been up, or are they signs that are new, or when did they go up?
Licensee has confirmed that the drink driving one has always been. There are newer signs over the course of time that have been printed off as well by the police. And so it depends on what the police has available, but signs vary. But what you see there now is current, and also have been there for about 4 months.
So you're saying these signs have been there for 4 months?
Maybe 2 months for the spiking one.
Now, then we go to a picture with 3 signs. And what are these signs for, please?
At the under 25s
Challenge 20.
challenge 25.
So the license is not your license summary, is it?
It's the whole pack, yes. They come down and check it.
But it's not the premises license summary, is it?
Yes, it's the whole start. Everything of the license is all in that clip frame.
So
They take it off.
it looks,
Come down and they check it. So they go behind the bar, they take it out, they look at it, and then they leave.
I'm going to suggest to you it's the wrong part of the license that's on display.
License in there.
But it's not the right bit that's on display, is it? You surely must know this. You've got a personal license, haven't you? You're the DPS.
Licensing come down regularly, check it.
It's not all of it, is it?
The whole summary needs to be on display. It can be pages pinned together. It doesn't have to be on
That's
display.
It's all in there. That's what I've been saying, is that
I understand.
it can be taken down, and there's also a different copy behind the bar as well that can be
When-
easily accessed.
When we've had our checks, they come down and they take that out and have a look at it.
The person looking at that's not going to have access to taking the sign, taking the notice part and
They come behind the
undoing the
bar.
license and having a look.
They come, licensing come behind the bar.
It's the police that come down.
Yes, but it's meant to be available for people, for members of the public.
It is meant to be available, that's absolutely correct. There's no requirement for it to be each page individually displayed,
Summary has to be on.
Yes,
That will say.
but not consecutively. Right.
Moving on from there, so then we've gone to drug scientists looked at that in the toilets, and again, is this something which has been up for a period of time, or is this just?
They've been up.
Yeah, they've been up.
Time on.
Yeah, we've always had
We have-
different posters of them, but they've always been along the lines of, they've always been, do not, obviously no drugs.
We have
please.
changed the location of it though, because the ones that we put elsewhere, they do just grab them off and rip them. So we have moved this one now to by the sinks, so they're more visible for everyone to see rather than just being in a toilet on its own.
And again, put another drugs sign. Then we go to the radios, which I'm anticipating you're saying, well, we've got the radios already, and we use the radios.
Yes.
Well, in fact, I know that there's not confirmation within the independent report, but you can see clearly from the age of those radios and also previously provided invoices and orders that the radios have always been in situ and they've always been used. So this is not new. It's simply producing a photograph of what they look like as more recent evidence.
We then go to a noise management plan. And this comes up with decibel reading. Who was put together the noise management?
You have done it together, haven't you? So this was put together between both licensees.
Do have one of our friends, Dave, he is part of it, he is a sound engineer.
Yeah, from Stacey's Music Limited. So he does help us out on the certain guidelines we do need.
That's also evidence that was produced before the previous hearing. There's reference to Stacey's and that there's been a noise acoustics individual, the engineer that has attended the premises.
And has that engineer been put in contact with Travelodge in order to try and ensure that these limits that are figures that are set here, that they've come from anywhere or that they
There's
wasn't?
never had a need to.
There's never been a need to.
Sorry, I did miss that. When was the noise management plan put together? Because obviously I thought we only received it on Friday.
I will check, but my understanding is that it's been in place since the 12th of April this year. So it's certainly way before this complaint.
But only produced on Friday in the papers.
It's
Because
listed.
we were asked for it.
Right, okay, thank you.
Then go through a dispersal wind down policy. I'm going to suggest to you that at your wind down period, the noise gets greater, not less.
The music goes off, then the doorman slowly move them out, not in all at once. It's kind of in groups and then disperse them to.
Say that during the wind down period, 15 minutes before closing time, during this time, music volume is reduced gradually.
It goes off.
So to calm atmosphere. I'm suggesting to you that the observations suggest that the volume increases from 130 and it goes off all of a sudden.
Well, I disagree
There
with that.
isn't any evidence that's been produced to that extent. I mean, there's again, and I have already highlighted the issues that I have with that report. Now, there isn't anything by way of actual noise measurements or decibels that's been taken to confirm the same. I'll leave that there.
I think it's probably introduced with the sound meter that has been acquired. So I'm guessing that's a new document.
They can, sorry?
This Alley Garden noise check procedure.
That's the reason you didn't.
Yeah, so you can see it's the same as what's been produced, and that we're not going into the semantics of the report because we're not permitted to do so. But it's, again, I should highlight this has been done as a goodwill gesture and with the aim of certainly satisfying both the applicant and also the travel lodge that we're going over and beyond what we need to do to ensure compliance with the conditions of the license.
Sorry, can I just, apologies to jump in. Can I just jump back a moment? You said that after 1:30 the noise is increased. Was that the submission that you made? The consultant's report says at 1:45 the music was reduced.
Nice is that.
It might, yeah, it would help if you could take us to the evidence for.
And carry on as much as they like. It's fine.
Some of that water.
Oh, please go ahead.
Thank you. Thanks.
Yeah, sorry, I've got Mr. Bailey's report now here. He says after 1:30 the music only seemed to get louder. Right, okay, thank you. It's Mr. and then Mr. Nevitt says his evidence is at 1:45 the music was reduced. Thank you. Want to clarify.
Again, it's just been clarified that this isn't in a document. This has been copied from the venue's website. And so in order to actually produce it without having to put the website before the committee, it had to be copy and pasted. It is therefore right that the committee can accept, there's been a COVID-19 policy as well that was in place in 2020, which again substantiates the licensees' evidence that they've had policies in place for 5 years. Nonetheless, what's on their website. So I accept that you don't like the wording, but that's what's on the website.
and they're put into a fire bucket out of the bucket with sand.
And the next photograph is is that the fire bucket?
Correct.
I don't know what the next photograph is.
That's the fireproofing in the cellar on the ceiling. Because it was again in the report that hadn't taken place.
Yes.
I think in the report, it says there's not proper compartmentalisation.
I didn't think it was necessary.
Is that,
He didn't think it was necessary. Yeah. Mark. Crowley, I think Mark Crowley. Yeah.
Point. The inspector that is or has inspected the premises did not actually confirm that that is necessary at all. He felt it wasn't necessary, so we may be at arm's length as to preferences by the landlord. But as I say, the fire safety individuals and fire service have confirmed that they're happy and they're satisfied with the condition of the property.
basement door has not been replaced with FD60. Is that?
But that's the applicant's fire safety investigator. It's not ours. And again,
So.
again, that's not actually a report. It's a draft. There are no reports that are, yeah. Well, we haven't produced that at this hearing. It's something for the county courts. I think it's been clarified already. The data I gave you relates to the county court's directions, and there's got to be a meeting between the experts. They do have some leverage of when they will be coming up with a combined report. I understood that the committee is not going to be concerned with this today.
No, we don't want to get, that's a separate case by a separate court. Thank you.
Fire guys have been in the kitchen, even though there's a fire extinguisher in there.
So in respect of fire safety issues, we say we highlighted issues all the way back since 2024. Why is it only in the last couple of months that you're starting to address this?
I think we have to be very careful to not be seen to make allegations in a way where it may seem slightly disingenuous. The committee has before it inspection certificates, zone charts, fire marshal training and certificates, fire brigade emails. There's been compliance throughout. I know at the outset, there was certainly a reference to documents not being available and that the landlord was concerned about that, but that's never been the position. Any documents that relate to prior to the licensees occupying this premises, they had to obtain from the previous occupier. And so I just want to clarify that there's not been no cooperation. There's a clear misunderstanding of the position in any event. But I would urge the committee to just have a look at what is actually before it, in addition to that which has been provided last week. And I'm happy to go through those documents, which include the PAT report, Langspark, cocktail, fire certificates, gas inspections, 2025, reports from the fire service, and so on and so forth. It is there.
Is it that we don't have any documents before the date that I asked for them? Not a single fire risk assessment, nothing. And the first fire risk assessment that took Mr. Dawson 8 months to produce says on the very front page, no previous fire risk assessment.
Which one is that?
Why have you got no documents whatsoever?
So Ian Whitfield had the business before us. We took over at the end of
Yeah.
COVID.
So I don't know if you were able to hear that, but Ian Woodfield had the business before these two licensees. And when the business was handed over to them, the two of them, they had to go to great extent to actually get documents from Ian Whitfield. I accept that there may be a document referring to that there isn't a previous fire check, but that may just be in relation to that engineer. And I don't want to speculate, but I think that's inaccurate. I think the committee can take some direction, perhaps from the fire service that have been around for decades, perhaps centuries, as to whether inspections have taken place at the premises. It's not a question that I think I should answer, because it will fall on them to say if it's happened or not.
Could you just clarify that, please?
Yeah, there has been previously not a lot of engagement at Langs. We work on a risk-based intervention programs. We have much higher risk premises that obviously call on our time more. As far as the fire risk assessment is concerned, we look at the current one and sometimes one before, nothing more, because anything before that is irrelevant, because the assessment, like when we do our inspection, is correct at the time. Having an, for example, an MOT certificate from 5 years ago doesn't make it a safe car now. So we don't look for years, previous fire risk assessments.
Thank you very much. Very helpful. In respect of, I think there's two matters that I just wanted to ask about, Sarah, and then I will have finished. When the fire officers attend in September, the propane containers are removed from site, and there are no gas heaters at the premises. Sorry?
They were empty.
Okay, well, I think the fire officer said that they weren't there. So the point that I'm looking to raise is that on the 14th of November, when the fire expert attends the premises, there are propane and patio gas heaters present.
I did say they didn't work as well. They didn't work.
So you're saying that they're there, but they don't work?
They've just been left there. They've gone now, but they were just left there because they were put out a year before ago in the winter. Then my mistake, I did leave them in the rain, being clever.
And the final, I think, point in relation to the premises is that the fire expert talks about, because of the safety of the premises, that there's an occupancy, it should be 60, including staff. Now, you operate a clicker system, so you will be able to tell us how many people you would often have in the premises.
So the standard is, from what we understand from our doorman, obviously company who have told us, they go by 80 to 100 people per doorman. Obviously, we don't want anywhere near that, because since COVID started, well, when COVID did kind of come to an end, we still thought, actually, if we put a policy in place where we have maximum 140 people, that's including garden area, potentially sometimes 10 over, but only if it's when the third doorman's on. So that's generally what we go to as a, but I mean, Friday nights are generally quieter nights anyway. I mean, Friday night, we generally, I mean, how much would you say on a Friday?
60 to 80.
Yes, 60, 80 really on a Friday. It's just with the Saturdays, obviously we have the third doorman, allow a little bit more in.
And the door, just to make it aware that the front door is being changed this evening. It was meant to be done yesterday, but he sent an email saying he couldn't attend, but the builder is actually making the door so it goes on the way of
Outwards.
where they move, like direction.
Yeah.
So the front door now opens outwards.
Now, or is in the process of
Well,
being
it's in the
changed?
process of being done.
In the process of being done. So it's not a now, is it?
Well, it was meant to be done yesterday, but he emailed yesterday, he couldn't do it. And we've got the email to clarify if that needs to be seen.
So comments in the papers which say all doors are outward opening is not true, is it? Again, these documents that you've put in, you're saying, yeah, they're all open outwards, but in reality, that's still not the case, is it?
Just the front door.
The front door was highlighted as that there would be an appointment on the 23rd in the papers. Everything else is compliant.
So
14th of November, the fire expert said it was an inwards opening fire escape.
yeah.
That's
So
the front door only.
No, the side, the gate that leads out into the side, it's opened outwards. Okay, then I must have misunderstood which door it is.
so
Can I just
coming back
say-
to the capacity, sorry.
There are also multiple exits. There's not just one exit.
So when you work out capacity, so you can use floor space, but we can use final exits. You discount one door
Yes,
and then you work out the occupancy of the other two, which is 200 people.
but in reality, we're not talking about two. I know you're
But that's the
treating
guidance.
you're treating a door, one of the doors, as a fire exit, and it isn't. Well, I'm relying upon somebody who's looked at this and knows what they're talking about, and they're saying very clearly that the occupancy should be restricted to 60. And what you're saying is that
Matters regarding safe capacities are normally dealt with under fire legislation, so the regulatory reform order rather than a premise licence condition. That's submissions on that for you to consider.
Yeah, could we? Thank you. Mr. Rees-Gay, have you got any questions?
No questions, Chair. Thank you.
Any questions? No, no, I haven't got any.
I just wanted to clarify one matter about the complaints that have been received. There's two sort of types of complaint that have been included. There's the Travelodge, the sort of external reviews, but also the Travelodge. They're called internal complaints. Are they complaints that were directly made to the hotel, or are they responses to feedback requests? It's just they come with a score, and so that would suggest that perhaps it's, sometimes after you've been somewhere you get a.
I don't know. I'll text quickly, but my understanding is it's when you get a follow-up email about your stay, that's what's been put in.
Rather than a contemporaneous,
I
someone's
believe
gone
so,
down.
please let me check.
Yeah, that's fine. We'll do closing and that might help.
Right.
Apologies, Chair. I just wanted to, obviously in your deliberation, you're going to be looking at a number of conditions that have been put forward by both the applicant and by Travelodge. So before you do that, obviously the applicant and Travelodge have had their opportunity to comment on those conditions. There were a couple I wanted to pick up with the licence holders, if that's okay. Now, you've given submissions on the impact of the conditions generally on your business. but I just thought it might be helpful if I could just go through and pick up any that there are particular questions on. There's a submission made regarding reducing licensable activities to 11 p.m, 10 p.m, or another hour. What would be the impact of that on your business?
Yeah, that would be our busiest period, is between 10:30 to 12 is when we start getting people come in, and then they just stay through the night. So personally, I think that time frame would be unrealistic and unreasonable, considering we've been there for a while now, and we've already put in everything in place that we can and have been doing for a long time. We've never had any issues with any authorities or anyone. So I feel this would be unfair, and it's almost a tactical choice for that time frame particularly.
Thank you. Moving through the conditions, I don't intend to ask about all of them because some of them you've already provided submissions on, but just ones where I think it might be helpful if you could provide some additional comments. Regarding SIA, do they use radios?
They use radios, they use clickers, it's all through a separate company called Mavco. He obviously does all the training. Obviously he does everything to do with that. I just source him for my security, and then we provide the radios, the clickers to make sure they have them. We have the little UV scanners as well on the key rings.
Thank you. High-vis jackets.
High-vis jackets.
They all already do that.
They have them with them. They don't always wear them. They have their, I don't know, how do you describe it?
He wears security wear lanyards, or they wear their luminous bands.
Yeah.
Thank you. Generally, sort of customer management of the door staff and the role, there's some quite prescriptive conditions that were put forward regarding asking customers not to stand around talking, for example. Do you have any submissions on how the door staff interact with customers?
I mean,
generally,
we don't really get any complaints about our door staff, really. They're quite, how would you have any answers to that, really? It's just...
A lot of people very rarely hang out the front. If they're leaving the venue, that they're in a cab straight outside, or they're walking back to where they're living, or whatever. It's very rarely that they linger out the front.
Okay.
And also, we do have a little bit of a reputation in town for being OTT with our kind of rules that we have in place. So that generally goes in our favour. And I'm quite friendly with a lot of the other bars, so they know the rules we have in place, and they kind of mention them when they're in there with their customers as well anyway. So it's kind of just a lot of, people don't really bother trying to do it if they don't.
What about body worn video? Body worn video.
They don't have videos, no.
Okay.
But if that's something that...
There is CCTV at the door,
Yeah.
though, that points to individuals both coming and going.
Yeah.
And the SIS staff can be seen from behind.
Is there a pub watch?
No.
As well.
We did.
Oh, right, yeah.
We did have a lady called Tiffany. She did come down to our venue once, and did offer it to us. And we did want to go through for a radio, but she said that there wasn't any around for us to go in for at the time.
I think it was that a while ago. It did change, and it's now in-house council one. So, but I can put you the details for that.
Thank you. Noise limiter. There's a request for a condition of a noise limiter. Do you have one in place now? Do you have any submissions? Okay, thank you. Loudspeakers, external loudspeakers. Do you have any? Loudspeakers externally. And there is there's a request for a condition that you don't have those. What would be your submissions on that? Thank you. There are also requests for conditions regarding So, an ID scanner.
IDs as well. So I think getting a system in, one, we don't get that much trouble in things, but and secondly,
Thank you. Right, that deals with the conditions that you haven't made submissions on from the applicant. Travelodge have also requested some conditions, mostly regarding noise inaudibility. Because patrons shall not use external areas after 10 p.m. What would be the impact on your business? Where would your smokers go? What would you do with them if after 10 o'clock they didn't? Thank you.
The applicant, which is Mark 11, which it's asking the authorize a condition that would require windows and external doors to be kept closed after 9 o'clock in the evening. So, I mean, that's inherently dangerous either way. Then also suggest that individuals should smoke inside, because that would be the alternative.
The two sets of conditions obviously are from different parties, and what the committee will do is they're going to go through each and everything. Yeah, thank you. The Travelodge conditions refer to nearby residential premises. Do you know where your nearest residential premises is? Thank you very much, Chair. That's all my questions on the conditions that weren't answered. Thank you.
Thank you, Helen. Would the applicant give us a brief summary? Thank you very much. Mr. Rees-Gay.
Chair, thank you. 63 rooms. Customers receive the survey 2 days after they check out, and they then have 2 weeks to fill them out. So can be within a 2-week period. They will fill, sorry, when they fill it out, it provides us with the details of where they stay, which room, and the date. I then pushed back and said, how about desk complainants? They may have complained at the desk too, and then filled out the survey as well, as a lot of people think they may get a refund. I have not got evidence of people complaining at the desk, but will do so moving forward. That was in relation to your queries. Just in terms of points picked up going through, so I disagree with the statement that the licensee has been put to task in relation to noise. The application was submitted on the 16th of September. It was this Friday that we first saw the noise management plan on the 21st of November, 5 weeks after Environmental Health requested that it be dealt with via a noise management plan. It's our belief that EH still haven't seen that plan. And indeed, I simply just don't agree that it was produced in April. Why on earth would the licence holder not have liaised with Environmental Health and agreed this by now? In terms of the submissions on the data this morning, you've had my points on that, please. Impact on the business was mentioned a lot by the premises holder. Indeed, Lang's behaviour is having a real impact on our client's business, if you could please note that. The police's email, we say, is not relevant to public nuisance. That relates to crime and disorder. There's been nothing tactical about the timings that we've requested. People simply sleep and go to hotels between 2300 and 0700, and therefore you would expect not to be affected by noise between those times. In terms of the noise limiter being requested and the premises licence holder saying the speakers aren't loud enough, clearly they are loud enough if we're receiving complaints in our hotel about loud noise from the premises. Therefore, we would request a noise limiter should you get there. There is a real issue, we say, with noise at Lang's. This is evidenced in the external complaints on Google and Travelodge, as well as the Travelodge internal reports themselves contained within the witness statements. It is evidenced. We are seeking a reduction in hours and the conditions to be applied to the licence to ensure that noise moving forward is not an issue. If you're not minded to reduce the hours, then we will request the inaudibility condition at noise-sensitive premises, and failing that, a noise limiter as a minimum, please. Thank you, Chair.
Thank you, Mr. Rees-Gay.
Just to sort of clarify, we've attended Lang's, both announced and unannounced. They've always engaged with us. They've always worked with us. They've completed works in a timely fashion. And actually the fire safety order is reasonably practicable, which means you have to take in consideration the cost of it as well. So we, give people longer to get stuff done if there's a bigger cost. So things like fire doors, they need work doing to them, but we know that and they know that. As far as the expert reports and stuff like that, I can't comment because we don't know competencies. All I can say is we audit Article 50 guidance, which is that guidance off of the fire safety law, and that's the consistent approach that we do. Thank you.
It's mine.